Good morning, everyone. What I've tried to do in preparing this talk is to cover as wide a range of topics as possible and to pick cases that are most likely to be of interest and have a practical impact on business. And the slide there sets out the topics the cases I will talk about relate to. So the first case is on compensation and discrimination cases, Chagga versus Abinational PLC, and you may have already heard about this case because there was a lot of excitement about it as it went through the Employment Tribunal and Employment Appeal Tribunal because the damages awarded to the claimant were in excess of £2.8 million plus interest, and that was damages in relation to lost earnings, past and future earnings, plus injury to feelings and certain other things. Now, the amount of that award was actually reduced greatly at the Court of Appeal level on a technical point, but the principles established by the earlier decisions remain, and i.e. the principle of career loss damages or stigma damages as set out on the slide. And the facts of that case involved Mr. Chagga, a man of Indian origin, employed as a trading risk controller at Abinational PLC, earning in excess of £100,000 per annum. In 2006, Mr. Chagga was made redundant, having been selected from a pool of 2 people, and he brought a claim for unfair dismissal and race discrimination, arguing that the decision to choose him over the other person was tainted by discrimination on the grounds of his race. He was successful in that claim, and the Employment Tribunal made an award compensating the claimant for loss of earnings for the rest of his working life, i.e. up to the age of 65. Hence the term career-wide loss, and the damages awarded included an amount in respect of stigma damages. So the court and tribunal found that Mr. Chagga would never again find another job in the financial services industry and awarded damages accordingly. But I think it's interesting to note in this case that the evidence in relation to mitigation provided by Mr. Chagga were truly extraordinary, and he was able to show that he applied for over 111 roles and that he was considered for even more. He recruited over 26 recruitment agents in his attempts to try and find a new job. He applied for roles that were outside his area of expertise. He applied for roles that were of less seniority than the position he held at Abinational, and he even applied for certain jobs within Abinational itself, albeit in other departments. All of those efforts were unsuccessful, and in the end he retrained to be a maths teacher at a secondary school, and we all know that your average maths teacher does not earn anywhere near £100,000 a year, and that's why his loss of earnings going forward were particularly high. And the Court of Appeal had the final say on this matter and also upheld the principle that recoverable loss is not limited to loss from the original employer. So the original employer remains liable for, say, stigma loss, and what stigma loss is the loss suffered by the fact that an employee may, or an individual may, find it more difficult to find a new job going forward, because employers would be reluctant to take them on if they know that they brought race discrimination or other discrimination proceedings against their previous employer. The court did, however, make the point that stigma loss will require extensive evidence, and it's likely to be part of a lump sum compensation payment rather than a figure on its own. And also, before panicking, I think it's important to note that it is quite hard to show that if an individual is unsuccessful in applying for a new job, the reason why they are unsuccessful was because of stigma rather than for some other reason. And stigma damages also assumes that there is some publicity around the case in question. An individual needs to be careful and, although be honest on the one hand with the potential future employers, they can't simply advertise the fact that they have brought claims against their previous employer. So the conduct of the individual is important as well, although going forward we are likely to see career-wide damages being sought by claimants. The second case is on disability discrimination and some guidance given to tribunals on how to approach mental illness in disability discrimination cases. And the facts of this case involved a qualified barrister with a history of depression who in June 2008 applied for a job at DLA Piper and got it, subject to completing a health questionnaire. And before she completed the health questionnaire, the individual in this case talked to HR and explained her history of depression. A few days after she completed the questionnaire, the job offer was withdrawn because DLA Piper said it was putting in place a recruitment freeze because of the economic climate. Jay was obviously not convinced by this and brought a claim for disability discrimination. And the preliminary question, this case was concerned with whether or not she was disabled. And just a quick reminder of general principles when an employment tribunal or court is considering whether or not an individual is disabled, it asks itself 4 questions. 1, whether or not there is a physical or mental impairment. 2, whether that impairment has an adverse effect on the individual's ability to carry out day-to-day activities. 3, whether that effect is substantial. And 4, whether that effect is long-term in this context, meaning it lasts for 12 months or more. And of course, tribunals generally follow those questions in that order, but the Employment Appeal Tribunal in this case said that the employment tribunals do not need to be very rigid in their approach to these 4 questions, and they said that if the question of whether or not an impairment exists is very complicated, as it generally is with mental illness, if examination of that point would involve complex medical opinions, etc., then the tribunal can go straight on to question 2, i.e. whether or not there is an adverse effect on the ability to carry out day-to-day activities, to make findings in relation to that adverse effect point and then move on from there. So park the existence of the impairment question until that point. And the other point made by the Employment Appeal Tribunal is that employment tribunals should be aware of the distinction between clinical depression and a reaction to adverse circumstances, because only clinical depression is protected under the Disability Discrimination Act and now the Equality Act 2010, although the symptoms of the 2 illnesses is similar. For example, lack of concentration, inability to sleep or to relate to other people socially, etc. And what helps to draw the distinction between whether a particular condition is clinical depression or a reaction to adverse circumstances is the last question in relation to long-term effect. The long-term effect question generally draws the line between the 2, and clinical depression is likely to last longer and have long-term effect. The next case is on whistleblowing and involves an unusual set of facts. It's a whistleblowing claim brought against a current employer in relation to a disclosure made in previous employment. The facts of this case involved Petrotechnics, a company that oversaw and evaluated safety processes for BP, and initially was the employer of the claimant in this case. And now Petrotechnics dismissed the claimant for gross misconduct because he told 2 senior BP employees about safety concerns that he had. Petrotechnics felt this was a breach of the individual's duty of confidentiality and that he divulged confidential information. and so they dismissed him. But 3 days later, he started a consultancy role with BP. And when he came to discussing the possibility of further consultancy work with BP said they were not prepared to engage him at all because they found out that he was dismissed for gross misconduct. So the claimant brought a whistleblowing claim against BP, and the preliminary issue in this case is whether the claimant can do that, whether he can proceed with a case against BP even though he was not working for BP when he made his protected disclosure. So the 2 points in issue in this particular case was whether an individual must be a worker when a protected disclosure is made, and secondly, whether they have to be the worker of the employer they then bring a claim against. The claimant was saying he doesn't have to be a worker at all when a disclosure was made, and even if he does have to be a worker, he could be the worker of any employer, not just the one that subjects him to a detriment, i.e. BP in this case. The employment tribunal held that a disclosure is not protected unless the individual is a worker when making the disclosure, and they came to this conclusion by looking at the wording of the statute itself, which refers to a worker making a disclosure, not, for example, a person making a protected disclosure. But they agreed with the claimant on the second point and said that you don't have to be the worker or employee of the entity, the employer, that subjects you to a detriment. And the reasoning behind this was that the tribunal took a purposive approach to the law, saying the purpose of the whistleblowing legislation is to protect those who have blown the whistle in the public interest, and that purpose would not be served if the protection is lost once the employer changes. And the Employment Appeal Tribunal agreed with that approach. However, I understand that BP has actually appealed to the Court of Appeal on this point, so the Court of Appeal will probably have the final say.